Thank you for joining us today. My name is Michaela Vrazdova Romesser, and I'm a senior associate at Scott Legal PC. So today we are going to spend some time and talk about the employment-based green cards, and we will focus on the EB2 and EB3 green cards, for which you generally need a company sponsorship from a U.S. employer. And this is also called PERM green card sponsorship. So a few things before we get started. So Scott Legal PC is a full-service immigration law firm, and we assist individuals pursuing various types of visas and green cards. We can assist you with family-based, employment-based, and investment-based visas and green cards, and we regularly process a high number of PERM employment-based green cards. We will continue to have this webinar series, and we'll do at least 2 webinars a month on different visa topics. At the end of this webinar, we'll send you out a few things. So we'll send you the PowerPoint we'll be using during this webinar. We'll also send you our PERM visa guide, which has comprehensive information about the PERM green card process. And we'll also send you a link where you can sign up for additional webinars we'll have in the future. And also this webinar will be made available on our YouTube channel, and you'll be able to access this. Finally, we'll also send you a link where you can schedule a consultation with one of our attorneys if you would like to discuss your particular situation in more detail. So finally, if you have any questions as we go through the presentation, please feel free to put it in the Q&A box or in the chat box, and we'll get to all the questions at the end of this webinar. Perfect. So how can you obtain an employment-based green card in the US? So there are, as you can see on this first slide, there are several employment-based green card categories, and we'll kind of go through them quickly, and then we are going to focus on the EB2 and EB3 green cards. So the EB1A green card is called Extraordinary Ability Green Card, and this is for people who have achieved extraordinary ability in their particular field. Usually for this type of green card, you have to show that you are kind of on top of your field, you have achieved national or international acclaim, and you are really kind of like an expert and well-known figure in your particular field. And we do have a separate webinar on the EB1A green card. So if you think, you could potentially qualify for this, I advise you to sign up for that webinar. The second category is EB1B green card category. So this is for outstanding researchers or professors. Again, for this green card, you would have to show that you have achieved some outstanding achievements in your field of research, or you are a professor. Then the third green card category would be EB1C green card category, and this is for multinational managers or executives. This green card is kind of similar to the L1A visa. The requirements, many of them are similar, some are different, but basically, for this green card to be able to qualify, you have to show that in the past you have kind of you were a manager or executive for a foreign company, and now you are coming to the US to work for a US company as a manager or executive, and there is kind of a those two companies are related. Either they are subsidiaries or parent-daughter company, or there is some relationship between those companies. Then the EB2 green card category. So for this green card category, you have to show that you have either an advanced degree or exceptional ability. So advanced degree generally means at least a master's degree or higher. So it could be master's, JD, PhD, any doctorate degree or higher. Or it could be bachelor's degree and then 5 years of progressive work experience. So this would be the EB2 category under the advanced degree. There is also an option to qualify under the exceptional ability. And for that, you would have to show that you meet at least 3 of these requirements that are enumerated in the regulations. For the EB2 category, you either need a company sponsorship for that. So that would be basically the PERM process. Or there is also an option to qualify under the national interest waiver. And under this option, under a national interest waiver, you potentially don't need a US employer to sponsor you. You could self-petition. But again, if you're kind of interested in the national interest waiver, I encourage you to sign up. We have a special webinar on that topic to sign up for that, as this webinar is going to focus more on the PERM process. So then the EB3 category. So this is for professionals, skilled and unskilled workers. So the professionals, those would be people who have a bachelor's degree. Skilled workers would be, someone who has at least 2 years of, education or experience or training. And then unskilled workers, those would be people who have less than 2 years of education, experience, or training. And for the EB3 category, that would be the PERM green card category, and you do need a company, to sponsor you for the EB3 green card category. The EB4 category, those are certain special immigrant green cards, and then EB5 green card, that is an investment-based green card. So for the EB5, you have to make an investment in the US, and then you have to create jobs in the US. And again, if this is something that interests you, we have special webinar on the EB5 green card. So now let's really focus on the EB2 and EB3 categories, and and kind of like the entire PERM and kind of green card process. So as I mentioned, you do need a company to kind of sponsor you for this type of green card. We often have many clients who are here on for example, E2 investor visas. They own the company 100%. And then they ask, can this company, I own 100%, sponsor me for the PERM? Unfortunately, this would not be possible. But what we often see in this situation is that, let's say that the investor is here on the E2 visa, but the investor has spouse. The spouse is often able to kind of find an employment in the US, and then that company then sponsors the spouse for the PERM, and then the E2 investor can then kind of join in the process as well. So this green card process, or the PERM process, is really kind of like a 3-step process. So the first step is called PERM. So and it has, as you see, kind of several kind of sub steps. So the first step, really, when a company wants to sponsor an employee for the PERM green card, really kind of the very first step would be drafting a job description. So the job description, it has to have information such as, what is the job title, what will be the job duties of this person, what are kind of the requirements, for someone to be able to perform the job. And really, the kind of let's focus a little bit on the job requirements. So, the PERM job requirements are kind of different than regular job requirements. So, I would say usually when an employer is drafting a job description and job requirements, they may require many skills, such as, good team player, good communication skills, things like that. For the PERM, really, the job requirements must be kind of minimum. So we have to, our kind of the standard is that, what would be kind of the absolute minimum job requirements for someone to be able to perform this job. So, you know, this is something to keep in mind, that, you know, like when the company is drafting the job description, that, you know, the job requirements will probably have to be kind of like much different than what the company would normally require, you know, just because, you know, again, kind of like the purpose of it is that, so, you know, like many, you know, so kind of like the most people who have kind of like these minimum job requirements can apply for this job. Then, you know, the next step, so once you have, once the job description is kind of drafted, then the next step in the process is to file a prevailing wage determination with the Department of Labor. This process, you know, once this is filed, it's going to take approximately, you know, at least 6 months, I would say 6 to 8, or, you know, even 6 to 10 months to kind of like get the prevailing wage determination back. And what the prevailing wage determination means is that, you know, the government will kind of like look at the job, the job duties, the job requirements. They will also look at kind of like which, you know, like geographic location, you know, will this person or the job kind of be performed. And then they will come back with kind of like a wage. You know, the U.S. company will have to pay the U.S. employee. The next step, you know, once you have the prevailing wage determination, is recruitment process. You know, this is going to depend on kind of like whether you are, you know, or whether the PERM is under the EB2 or EB3 category, because the recruitment kind of like requirements are a little bit different for these, but generally, you know, the U.S. employer will have to post certain advertisements, will have to run them for at least 30 days, and then, you know, the U.S. employer will basically have to interview kind of like all the candidates that apply, and then kind of like keep records, you know, if they, you know, like if someone doesn't qualify, you know, like keep records as to why this person didn't qualify, you know, like why this person didn't meet the requirements. You know, one thing to note here is that if the company does find a willing, able, and qualified U.S. worker, unfortunately, the PERM process will have to stop. But let's say that the company doesn't find anyone willing, able, and qualified to do the job. You know, then you can kind of like move on to the next step in the PERM process. So there are so the next step really would be kind of like filing of the actual PERM application with the Department of Labor. One thing to keep in mind is that all of these kind of, you know, the job description, the prevailing wage, the PERM, all of these filings are with the Department of Labor, and not you are kind of like not in the USCIS step yet. So all of this is happening with the Department of Labor. So, you know, the next step would be to file the application with the Department of Labor. Sometimes, you know, some applications may get audited. You know, the Department of Labor can really audit, you know, like any application, but like some audit triggers would be, for example, you know, like if the job requires a foreign language, you know, that is a common audit trigger requirement. You know, like let's say that the requirements really seem kind of like outside of those normally required for that occupation, you know, again, like that could trigger an audit by the Department of Labor. And what happens in the audit is that, you know, you would have to, or, you know, your employer would just kind of have to respond, you know, to, you know, like if the Department of Labor is asking for certain document or kind of like justification about the foreign language requirement, you would have to, you know, respond usually within 30 days. And, you know, so as I said, the prevailing wage, I would say currently is taking around 6 to 8 months in average. The recruitment process, as I said, the ads have to be run for 30 days, and then there usually has to be kind of like a 30-day quiet period. And then the PERM, the actual PERM is currently taking around like 11 to 12 months. So you see that, you know, that this whole process does take some time. Now, you know, let's say that the Department of Labor approves the PERM application. then the next step would be to file an I-140 petition, and this would be basically with USCIS. So now with this second step, you would be at the USCIS stage. It is possible to file the I-140 under premium processing. So this would, normally if you don't file under premium processing, the government, it would take, like several months for the government to kind of issue decision. If you file under premium processing, it means that they would adjudicate it within 15 business days. So it just kind of speeds up the process. And then the third step, so then let's say that the I-140 petition is approved, then you would move to the actual kind of green card process. And this could either happen by filing an I-485 with the USCIS. This usually happens like if you are already in the US on some other like non-immigrant status, then people file an I-485. If you are, like outside the US or, generally like for people who kind of like need to travel often, they can file it under consular processing. Now, to be able to kind of like get to the I-485 stage or to be able to apply for the actual green card, your category has to be current in the visa bulletin. So visa bulletin is something, the government kind of issues every month, and it kind of, for each employment-based category. So here for EB2, EB3, it kind of indicates, like who, like who can file this month. I would say like many nationals of many countries, the category is current, but there are some countries, for example, India, China, nationals of those countries, have to wait kind of like certain period of time until their category is current. And then one other thing to keep in mind is that, like if you are applying for a green card, you can include your spouse and then unmarried children under the age of 21 on the green card application. So let's kind of discuss these two options, the adjustment of status and then the consular processing in a little bit more detail. So the adjustment of status, as I said, like this would be an option. So you would have to file for I-485 with USCIS. For the adjustment of status, like you have to be already kind of like present in the US in a valid status to be able to kind of like be able to file the I-485. The advantage of the I-485 or kind of like adjusting the status is that it gives you ability to remain in the US. So like, let's say that you are kind of like currently here working, like let's say you're here on an H-1B status and you file an I-485. Like you can, you can kind of keep, like living in the US and working in the US, like based on the H-1B, like if you have kind of like a remaining period of time on that. And filing of the I-485 kind of gives you ability to kind of like stay here. With the I-485, you can also apply for a work and travel authorization. So once the work authorization is approved, you can work in the US like based on that work authorization. Once the travel authorization is approved, you can travel internationally based on the travel authorization. So that is a big advantage of filing adjustment of status. And then, the adjustment of status is going to take some time. So I would say like it generally takes about like year and a half, for kind of like this to be approved. And I would say most applicants will have an interview with the USCIS officer, but, sometimes they approve the application without interview. But in most cases, you would have to have an interview at your USCIS field office, kind of like the office that is, closest to where you are residing in the US. So the second option, like how to apply for the actual green card would be what is called consular processing. So this would basically mean that once USCIS approves the I-140 petition, they will send the approval to the National Visa Center. You would then submit, supporting documents to the National Visa Center. You would also have to submit a DS-260 form. It's kind of similar form as DS-160 if you are familiar with it from, like when you are applying for a non-immigrant visa. It just asks like even more detailed question about like your address, employment history, and things like that. And so, you would have to file kind of like all these documents to the National Visa Center. And then once the National Visa Center reviews these documents, they will send, the file to the consulate, of your home country. And then the consulate will basically schedule your interview. And then you will have to attend the interview. And then if everything is approved, if the immigrant visa is approved, they will issue an immigrant visa in your passport. And then, you would have to also pay for the actual green card once you are still outside the US. And then once you come to the US, you will receive the actual green card in mail. And as I said, the consular processing is for people, like let's say that you are residing outside the US and the US company is kind of sponsoring you for the PERM, but the whole time you are just residing outside the US, really your only option would be consular processing. And also, as I said, like people who kind of need to travel often, and they just cannot kind of like wait for the travel authorization. They would need under the adjustment of status because that's currently taking around 12 months. So if you're someone who kind of like needs to travel frequently, then the consular processing may be just kind of like a better option for you than the adjustment of status. So now, who can pay for the green card fees? So it's very clear in the regulations that the fees related to the actual PERM process must be paid by the sponsoring employer. So there is no way to kind of go around that. And then the fees for the I-140 petition and the actual green card petition for the employee and the employee's family, those can be paid either by the employer or by the employee. So there is flexibility in that stage. But the PERM process, like all those fees have to be paid by the US company. Sometimes we get a question, so like, let's say, for example, someone is asking that the US company kind of like drafted an agreement saying that, like they will pay for the PERM process, like all the fees, but like it will be deducted, like from the employee's payroll or something like that. So again, like it's not allowed even, under that arrangement. And all the fees must be, paid by the employer and cannot be kind of like be deducted or taken back from the employee. So now let's discuss a dual intent and then which visas have dual intent. So many non-immigrant visas do not allow for dual intent, like meaning that applicants, with visas that are single intent or non-dual intent must show that they do not intend to move to the US permanently. The advantage of the dual intent visas is that the applicants do not have to show that they do not intend to reside here permanently, meaning basically that they don't have to show that they are not planning to apply for a green card. So the dual intent visas are really H-1B visa and L visa. And what this really means, so let's say that you are in the US on an H-1B visa and you are undergoing the PERM sponsorship. So like, let's say that the green card process, the PERM process, or the actual, the I-140 was already filed, you would still be able to travel, like in and out on the H-1B visa. You could even renew the visa at the consulate, and they couldn't really question, like your intent or the fact that you have a green card petition pending, because, the H-1B visa is a dual intent visa, and it allows you to kind of like, be undergoing the green card process, even if you are in the US on the H-1B visa. And really, kind of like the true dual intent visas are H-1B visa and L visa. O visa, there is some support in the regulations for that. But the kind of like the true dual intent visas would be H-1B and L. So now let's say that you are, you are in the US on a, TN visa, which is not a dual intent visa. Then you have to be kind of just like really strategic with your, employer and your immigration attorney as to kind of like when the green card petition should be filed, because the TN visa, for a TN visa, you generally have to show that you do not intend to reside in the US permanently. So like, let's say that an I-140 is already filed, and then you want to renew your TN visa, you could have kind of like issues with that. So for, visas that are not H-1B LOs, it's very important to kind of like discuss kind of like the timeline of filing the green card, kind of like renewing the visa, and travel with your US employer and an immigration attorney. So let's discuss some considerations when moving from a visa to a green card. So, what is really important here is the timing and kind of like your underlying visa status. So, really, like we'll have to look at kind of like how much time you have left on your current underlying visa. As I said, like some visas, such as, for example, the TN, are harder to kind of like, extend or renew once an I-140 or a green card petition is filed. So as I said, like it's really important to kind of discuss the whole situation with the employer and your immigration attorney. Again, do you want to adjust status in the US, or do you want to go through the consular processing? And then one other thing to keep in mind is kind of like your, your family situation. So, do you have children that are soon going to turn 21? In this case, like you should consider kind of like talking to the speaking with the employer, your immigration attorney, and kind of like filing early to avoid kind of like issue with your children aging out at 21, because once they kind of once they turn 21, they would no longer be able to get the green card. So now, as I said, like in most situations, when you are filing the I-485, like you will have an interview at USCIS. And if you are applying at a consulate, you will always have an interview. So, what are some questions, like they can ask you, or kind of like how should you prepare for the interview? So, you should definitely spend some time and kind of review, the immigrant visa petition, the I-140 petition, and the whole green card petition, either the I-485 or the DS-260. Then you should, like organize and print all the documents and bring to the interview. You should gather required original documents. So, you will have to show your original birth certificate, your marriage certificate, and if you have children, also their birth certificates. So you will have to present the originals. The consulate, they usually just take a look at the originals and then you provide them copies, but you do need those originals. So it's really important to kind of like, if you don't have them, to kind of like start like gathering these, in advance of the interview. Also, you will have to submit your medical exam form. So just make sure, like that's valid. You should get an updated proof of employment from the sponsoring employer. And then if you are adjusting status in the US, you will have to show that you are maintaining your status. So this would kind of depend on, like what is your current, like visa status, but, like you will have to show evidence that you have been maintaining status. There is kind of like no gap in your status or anything like that. And, it's always helpful to kind of like meet with your attorney, like schedule a quick call and do a practice interview just to be a little bit more prepared. And now, so what is porting, and can you change employers during the process? So porting really means, it kind of like allows employees to change employers, but only once the I-485 petition, the adjustment of status petition, has been pending for at least 180 days, and the I-140 has been, has been approved. So, you know, the advantage of the porting is that, you know, like, let's say that you have an I-140 approved, and the I-485 has been pending for at least the required period of time. You can, you know, you can change employers, and the advantage of this process is that the new employer doesn't have to go through like the new PERM or I-140 process again. So the new employer wouldn't have to do the, you know, the prevailing wage determination, the PERM, you know, the I-140 filing. So this is really, you know, a great advantage if you do, you know, if the I-140 has been approved and the I-485 has been pending for the required period of time. Now, you know, for you to be able to qualify, you know, under the porting, the new employment must be in the same or similar occupational classification. So obviously it cannot be like in a completely like, you know, like unrelated field. You know, it has to be similar occupational classification as the, you know, as the job on the I-140. So, you know, like this will be really kind of like important for you to document. And, you know, one other question we kind of, you know, get sometimes is, you know, like once you know, let's say that you obtain your green card under the PERM, and, you know, the question is, you know, like how soon can I change employers, you know, like after I get a green card, you know, like for, you know, like from this employer. So I would say there are two things to keep in mind here. You know, like one is that, you know, like when you are kind of obtaining an employment-based green card, like you are making good faith attestations, you know, like on the forms that you intend to continue working for the company that is sponsoring you for the green card. I would say that, you know, like circumstances may change, of course, but definitely, you know, like if you get the green card and then quit, you know, like a day or two later, 2 days later, that would not, you know, like look best, you know, like during the like when you apply to, when you plan to apply for citizenship. So I would say like you generally kind of like want to stay and kind of like keep working for the employer for kind of like reasonable period of time. And again, you know, like, of course, your circumstances may change, like you may need to move. And this is something, of course, that, you know, like you could explain at the naturalization interview. But as I said, like if you quit, you know, under, you know, like after like 1 day after you get the green card, you know, like there, you know, the officer may kind of like notice it during the naturalization process. And this is something, you know, they could definitely ask questions about. And even I would say, like, even if, you know, you quit, you know, like few weeks after or a couple months, you know, like you should always be kind of like ready to explain, you know, like what happened and kind of like why you quit, you know, during kind of like the naturalization process. Perfect. So that was the presentation. I don't see any questions here. So thank you again for joining us today, and we'll send over the guide and kind of like all the documents I discussed in the beginning. Thank you.